Hello. Thank you all for coming. I'm A.G. Harmon, and this is the first of our presentations in the 2011-2012 Student Scholars Series. The series was instituted 4 years ago in order to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by third-year student Kelsey Darnell. Before I introduce Kelsey, I'd like to first introduce the respondent to her presentation, Professor Lucia Selecchia, a graduate of Yale Law School, where she was senior editor of the Yale Law Journal. Professor Selecchia has taught at Catholic University's Columbus School of Law for over 20 years. She has been an ordinary professor since 2004 and served as the law school's associate dean for academic affairs in 2004 and 2005. She also serves as the co-director of Catholic University's new International Human Rights Summer Law program in Rome. She teaches or has taught environmental law, property, trust, and estates, corporations, among other subjects, and we're honored to have her here today. Now, let me introduce our presenter today, Kelsey Darnell. A graduate of Georgetown University, she received her degree in finance and management. Kelsey has spent the last 4 summers working for Carney and Callahan in Columbia, Maryland. Last fall, she interned with the Office of Case Management, writing family law orders for the Circuit Court of Anne Arundel County, and she plans to clerk in the Circuit Court of Anne Arundel County in the chambers of Judge Michelle Jacklich after graduation. Kelsey's interest in the subject she will speak on today arose from a Washington Post article which discussed the different state rulings on the inheritance of Social Security benefits by posthumously conceived children, and she's going to explain what that means. It sounds a bit oxymoronic, but it's something she's going to explain to you. Her interest was particularly piqued by the fact that advanced productive technologies so greatly impact the inheritance rights of children. Her article was written for the Catholic University Law Review, who nominated it for consideration by the committee, and we thank them for doing so. I'll now turn the floor over to the first of this year's student scholars, Kelsey Darnell. The title of her presentation, Legislation Frozen in Time, Persistent Problems with Attempts at Uniformity for Social Security Inheritance Rights of Posthumous Children. Kelsey.
Good afternoon. I just want to say thank you to all of you who came today. I see a lot of familiar faces, and I just want to say thank you for the support. Definitely couldn't have done all of this without the help of professors and friends and support from Law Review. Before I start, I am going to explain what a posthumous child is. The context that we're talking about is specifically where the husband passes away, but prior to passing away, he provides genetic material that is then used by the wife after his death to conceive a child. So the child is not in utero when the father passes away. States have consistently held in that case that the child would be a child of the parent. So that's not the case that we're talking about. We're talking about specifically where the wife conceives the child after the father's death. So I'm going to start with the Social Security Act, and this is the section that defines a child, and as you can see, it says nothing about posthumous children or posthumously conceived children, but it does state in the Act that the purpose is to provide for children of a Social Security beneficiary where the parent is no longer able to. This same section requires that a child be a dependent upon the parent in order to inherit, and this has been an issue that many states have discussed in determining whether or not a posthumously conceived child could inherit, because obviously we can't establish that such an individual was living at the time of the death of the parent, or that the child had depended on the parent for a specific period of time before passing. The Ninth Circuit actually used this requirement and basically kind of changed it into their own interpretation in order to hold that a child could inherit by saying that the child, even though they were not dependent upon the parent under the Social Security Act, they were still a legitimate child of the parent, and therefore they could inherit. On the other hand, the Middle District of Florida stated that a posthumously conceived child could not ever be dependent upon that parent that had passed away, and therefore they could not inherit Social Security benefits. So there is an alternate provision under the Social Security Act that provides that a child may be able to inherit if the state intestacy law provides for a posthumously conceived child. And these are the requirements that have to be met in order for a child to inherit in that way. As we'll see later on in the presentation, the Social Security Administration has actually recently held that a posthumously conceived child can only inherit by way of the intestacy laws in the state that is relevant for determining rights. Also, I just want to draw your attention to Section C, which allows the Commissioner of Social Security to interpret the state law, which might not be clear, and we'll see a lot of circumstances where that still is the case, that states have not provided specifically for a posthumously conceived child, and the Commissioner has the power or the authority to interpret that state law and determine whether or not that law would enable a child that was posthumously conceived to inherit. So, as I said before, the Social Security Administration has recently established that the only way that a posthumously conceived child can inherit is through Section 416H, which states that the state intestacy laws must allow that child to inherit. We've seen 4 different approaches so far by the states in those state intestacy laws. The first one is requiring a child to be in gestation at the time of the parent's death, and then the child must survive by 120 hours, which is 5 days. We've also seen states require an afterborn child to be conceived prior to the parent's death, so that was the situation that I was talking about at first that we aren't necessarily talking about today, because most states have accepted the fact that a child that is in utero at the time of the parent's death will inherit. Thirdly, allowing a posthumous child to inherit as if they were living at the death of the parent, and a lot of states have placed different standards on this right of inheritance, such as time limitations or written consent or intent of the parent. And then finally, many states do not approach the issue at all in their state laws.
Kelsey?
Yes.
Does it cost, financially, does it cost the state anything to say yes, the child who's conceived after the death of the parent? Does it actually cost the child anything? Does the parents state anything in terms of benefits they have to pay, or is it just a question of how they want to slice the family?
I think that I don't think it would cost the state anything because it's the federally funded Social Security benefit. So some states have started to address the issue of advanced reproductive technologies, which I'm going to refer to as ARTs for the sake of time. And some of them have provided specifically for posthumously conceived children by way of written consent, and also some form of intent that the deceased individual showed prior to death. Some examples are Georgia, Idaho, South Carolina, and Virginia all require an individual to be born within 300 days or 10 months of a parent's death. So that would mean not necessarily a child that was conceived prior to the parent's death, but very shortly thereafter. You can see how restrictive this might be on someone who has lost their husband and now they are fighting this time limitation. That's one of the issues that I will get into a little bit later. And then Wyoming and California use written consent, and a lot of times states that use written consent will require a very specific written consent. And so if the parents have not provided in this way for this type of situation, then the child will not be able to inherit, which is unfortunate. So one of the most important decisions is Woodward, and this was decided in 2002. They placed the burden of proof on the issue of consent to conception on the surviving parent. So the wife would have to prove that the husband both intended to have a child by way of ARTs following his death, and also that he intended to support the child. The court held that these posthumously conceived twins could inherit as long as they were biologically related, which they were, and also, as I said, where the decedent consented to both posthumous conception and support of the child. So what Woodward did not determine is that the court said that time limitations could possibly come into play, but this was not an issue in the case because the wife happened to conceive the children relatively quickly right after the husband had passed away. So they did not resolve this issue. And specifically, the court reasoned through its holding by looking at the Massachusetts state intestacy law. And there was no express provision requiring that posthumous children were in existence upon the death of the parent. And by that, the court said that the children could inherit as a child of the decedent because they were biologically related. Importantly, these three factors have been used by the courts, as we've seen over the past 10 years, ever since the Woodward decision. The best interest of the child, the orderly administration of the estate, and then the reproductive rights of the genetic parent, which you can see how intent of that parent and consent by that parent come into play in determining, whether or not they wanted that outcome. Another factor that I think has come up more recently is just an amount of certainty for the children and an amount of certainty for the other children that might be inheriting through the state intestacy laws. So the Ninth Circuit was the first federal court to consider this, and they applied Arizona state intestacy law to determine that the posthumous children were children. And again, they decided the dependency issue by saying that the children were legitimate children of the deceased individual. Intent was established by a presumption of paternity, which we see sometimes in trust and estates law, that since the husband and the wife were married when before the husband had passed away, that they assumed that the husband had consented to have a child with the wife by donating genetic material during his lifetime. And then the Ninth Circuit also required affirmative consent, but then presumed that the husband had given his wife permission and allowed her to testify that he had intended this result, but that was really all that was required. So it was a pretty low threshold. But again, as in Woodward, you see consent to conception and consent to support as a two-pronged inquiry. So this conflicts with the Social Security Act slightly because the holding allows children to inherit from the parent under the Social Security Act, even if the child cannot inherit under the state intestacy law. And as we saw at the very beginning, the Social Security Act refers to the state intestacy law for the determination of a child's benefits. Then we've also seen under Stephen that a written requirement might be required by states. The court concluded in Stephen that the child was not entitled to benefits because there was no written evidence that the deceased individual had intended this outcome. And the court also recognized once again that this type of child could not be dependent upon the deceased individual. In 2007, the court in New Hampshire applied the state statute and which would require that the child be surviving at the time of death of the decedent. So this is another slight variation of the state intestacy law that ended up having a negative effect on the child's right to receive benefits. It's slightly different from Woodward just because of that application of the state intestacy law. So the Ninth Circuit got another crack at it in 2009 in Vernoff, and they denied benefits this time because they were applying another state's law, and the state statute required a certain parent-child relationship before the child could inherit. So I just have here that this is one of those examples that shows you really the difference between state intestacy laws having a huge impact on whether or not the child's going to benefit under the federal scheme. These are just a few of the proposed laws. The National Conference provides states with guidelines for legislation. They're not required to enact them, but they're proposals. And the purpose is to provide a group of individuals to research, draft, and promote enactment of uniform state laws in areas such as this, where the state laws are somewhat inconsistent and the courts are struggling to figure out what to do. So in 1988, we have the Uniform Status of Children of Assisted Conception, and this was not used by very many states. But in 2002, we have the Uniform Parentage Act, which actually was enacted in several states. The UPA required written consent of a deceased individual before the posthumous child could inherit. And then in 2008, the UPC was amended, requiring, in addition to the consent requirement, that an individual be born within a specific period of time, which we'll see in a second what that time period was. So this is the UPA, and it required a man to provide intent and consent. The consent was pretty specific, and if one of those two prongs was missing, obviously the child would be unable to inherit. And here is that presumption of paternity within the presumption of the marital presumption as well. So the UPA was adopted by 9 states, and then we have the UPC, which allows a child either in utero, not later than 36 months, or born not later than 45 months after the individual's death, and also a consent requirement. Once again, the marital presumption was allowed to establish paternity of the deceased father, and that presumption results in a presumption of consent that we saw in Woodward as well, as long as no divorce is pending and where the birth mother is married. The restatement has a very different approach, and I'm not sure that it's used. I don't think it's used in most states, but it requires a reasonable time after the decedent's death and circumstances indicating the decedent would have approved the child's right to inherit. So this is really uncertain, even more uncertain than providing, consent or intent. And then the ABA came out in 2008 with a model act to try to approach the same topic. However, as we'll see, there were some issues just because a lot of the states at this point had enacted either the UPA or the UPC or some form of them, and the ABA Model Act specifically yields to previously enacted provisions of the UPA or the UPC. So the most popular is the Uniform Parentage Act with customization. And no state at the time that I wrote my article had approached the issue by merely redefining who a child was under the state intestacy law. There are some constitutional considerations that I just wanted to hit upon. First of all, it was established that rational basis scrutiny, which is the lowest level of scrutiny, is required for social welfare legislation, so the Social Security benefits, as long as they're rationally related to a state purpose, then they would be upheld. And then in Vernoff, the court emphasized the dual purpose of limiting benefits to children losing parents and also using reasonable presumptions to minimize the administrative burden of proving dependency on a case-by-case basis, being rationally related to the state's class distinctions. So Professor Slucky and I might talk about this a little bit more, but you can see that there are two major competing interests here, because you have the federal scheme on one hand, and the Social Security Act is for the purpose of providing for children when you have a deceased individual who can no longer work and provide for their family. And then on the other hand, you have the state law that is providing the intestacy law, where the child would take as long as the parent had not provided a last will and testament or other will substitute. And Congress and the Social Security Administration have traditionally left the issue of inheritance to the states, but as we'll see in a few minutes, the Supreme Court is going to be considering a narrow issue relating to this topic, and that all might be about to change. So just a summary of all the different standards that I talked about: the dependency or the state intestacy law under the Social Security Act, the consent, that specific consent or written consent, time limitations, other written requirements, and then the marital presumption coming into play as to whether or not how much the wife has to prove that the husband had consented to the posthumously conceived child and to support. So as I talked about a little bit before, the commissioner has some power over interpretation of the state law where it's unclear as to the posthumously conceived children, and there will be deference to the commissioner's final decision as long as it was not arbitrary, capricious, or an abuse of discretion. And then I touched on this a little bit, but the ABA Model Act defers to those previously enacted UPA or UPC related provisions. It also requires informed consent in a signed record and intent to be the parent after death, which is an extremely high standard. If you have a parent that might not necessarily have known the ramifications of providing genetic material and having the wife having that capability to use ARTs to have a child after the deceased death, then likely they didn't have a writing, and the child therefore would not be able to inherit. So the Social Security Administration's website claims that they have a very liberal approach to the award of benefits, those who are eligible and those who need support, which would clearly be a family where the father, especially if he was the breadwinner for the family, passed away. And the state also has a strong interest in determining the fair intestate succession rights of children, and also determining those in a timely manner so that we aren't dividing up the estate over 20 years into the future after the father's death. So the Eighth Circuit recently held that a posthumously conceived child could not receive survivor benefits under the Social Security Act, where the child could not inherit under the intestacy law. So in other words, the state intestacy law would have to provide for the child, and if it did not, then that child also would not be able to inherit Social Security benefits. This was decided pretty recently last summer. And the reasoning for this is because of the Iowa state law that didn't recognize any child born or begotten after the intestate's death. And then the Third Circuit, this is actually a pretty familiar scenario for a lot of the cases where the husband has cancer and has to undergo chemotherapy treatments, knows that it's going to affect his fertility, and decides to put away genetic material for later on in life. And then the husband passed away, and the wife gave birth to twins, then applied for Social Security benefits, and initially was denied under Florida law. But then the Third Circuit reversed, allowing benefits because the child was a biological offspring of the parent.
Why would the Third Circuit be applying Florida law?
I think because it was up on appeal.
But Florida's not the Third Circuit, that's my question.
One of the issues here was determining the state of residency of the parents, because they were married in one jurisdiction and then moved.
Sorry.
Maybe the husband was buried. He is a resident of sorts. Forgive me.
Apologize.
No, that's fine. So I just wanted to summarize a little bit. At this point, we have the Ninth Circuit in the first case we saw allowed the child to benefit even where the state intestacy law did not provide. And then the Ninth Circuit, again, in Vernoff, denied the child benefits because the deceased father did not knowingly donate genetic material and did not consent to its use. Also in the Fourth Circuit in Schaefer, the court recently denied benefits to a child because the child was born 7 years after the death of a parent, and Virginia has a time limit of 10 months. So the Supreme Court recently granted cert in this last case that I was just discussing. So this is especially relevant because the Supreme Court will be hearing oral arguments at the end of March. But the question that they are determining is pretty narrow. It is whether a child who is conceived after the death of a biological parent but who cannot inherit under that state intestacy law could otherwise inherit under the Social Security Act. So you can...
Is that a biological child?
A biological child, yes. So you can see that separation of powers issue at play where the state has traditionally had control over intestacy decisions, and now you have the federal scheme that if the Supreme Court comes down and says that the child who can't inherit under the state law can still inherit under the federal scheme, then you have some inconsistency. And that is it.
Well, I think what we'll do now is Professor Selecki will conduct a response. She has some questions for Kelsey to bring out some of the finer points of the presentation, and after that, we will have questions from the audience. Professor Selecki.
Well, thank you, Kelsey. And just a couple of comments in some of the broader context, because I think what Kelsey has hit on is a question that up until now has been looked at very narrowly, but has much broader implications. So far, the cases that we've looked at have typically involved a husband and a wife, and the husband has died. And that's been the typical scenario. We don't have many cases yet that involve, for example, a couple that is not married at the time of the death of one of the spouses. And I think figuring out the implications in that context is something the law has not done. We've also primarily looked at cases in which it is the father who has died. But I think in the future we're going to see more cases in which it is the mother of the child who has died. When we're taking a look at these cases, that may raise different questions. I also think it's interesting that almost every single one of these cases that has made its way up has been a Social Security case. It has not been fights over the person's intestate estate. And I think that's interesting for a couple of reasons. One is because very often these cases don't make it to the probate court because the parents have drafted around it in their will. Typically, if parents have planned for posthumous conception, these are not people who've died intestate. And yet the courts are using the intestacy statutes for determining Social Security benefits. So I think that's one of the mismatch issues. We're looking at an intestacy statute that is hardly ever used in these contexts. But the one in which another broader context in which this might come up is not the inheritance rights from parents, because parents have figured that out usually for themselves in a will. But there's a whole range of cases where, for example, it was the grandparent of one of these children who created a trust. Certainly did not consider what would happen to these children when you're interpreting a document drafted by somebody other than the children. So I think states' statutes, this reliance on state intestacy statutes, is somewhat misplaced because we haven't had much experience in the intestacy statute in this context, and I think the more interesting cases are the trust cases as well as some of the ones you've been talking about. So I guess my first question, and this is something that has bothered me about the way the Social Security Administration has approached this, has been this great degree of deference to what the state laws have done, in part because states use intestacy law for different purposes than this, and because they're designed to do different things. In allocating someone's estate, we care about the intent of the decedent.
Right.
And maybe we shouldn't care so much when it's Social Security benefits because it's not the decedent's property. When we're looking at intestacy statutes, we care about closing out the estate quickly and moving on through probate. We care about fairness to other beneficiaries. But when we're looking at Social Security payouts, those issues are not concerned. So I guess my question, in particular looking at the attention the Supreme Court is getting, is whether or not you think a good result would be for the Social Security Act to sever this connection to state law completely and say, let the states do whatever they want for inheritance. For Social Security, it means this, and have a completely different scheme for that, or do you think that this reliance on what the states do makes sense?
I definitely think it would cause a little bit of an issue if they decided that the Social Security Act was going to provide for this type of child and not refer to the state intestacy law, just because of that traditional deference to the state in this area of law. But I can also see the other side, that it would really make sense for these Social Security benefits, which presumably within the estate of the decedent, there would be so much more than just the Social Security benefits to that would go to the other children that might be able to take, or other descendants. But I'm not sure, but I don't think that the Social Security Act should change that deference that has been there for so long to the state intestacy law. I feel more that the state laws need to change in order to provide for these children.
And part of this deference to state law, I think, has been exactly as you said, this tradition of we defer to the states, because this definition of the parent-child relationship deals with inheritance, but it also deals with relationship between parent and child during life, and then parent and child for purposes of determining benefits. So I think part of the concern is, once you get a definition of child for Social Security purposes, will that start to meddle with the state's tradition of parent-child relationship, both for obligations during life and in intestacy? I think when I look at the very narrow question presented that you raised, I think that the Social Security Administration is doing exactly what the statute says when it defers to the state intestacy statutes. And I wouldn't be surprised if the court were to say they're doing what the statute says, and then whether or not that would then lead the Social Security Administration to change their minds on that one. The other thing that I found somewhat problematic, but I don't have the answer to the question, a lot of the states that have addressed this have put a lot of weight on parental consent. And they have said, we're concerned about the decedent parents' consent to having the child, and even in some, we're concerned about the decedent parents' consent to support the child.
Right.
And I think there is a very strong argument to be made that we should care a lot about what the decedent father in these cases thought. There have been some cases that haven't originated in this context, but in the medical ethics context, where the material is taken from the father without his knowledge and consent when he's comatose, right before
Right.
death. And that raises a whole host of ethical questions. And I would say, well, he didn't consent. Maybe we should treat these cases differently. And at the same time, that interest that the child has in support is the same regardless of the circumstances of his or her conception. And the last time that the court made a distinction between how we treat children has been all of the cases dealing with unmarried parents. And you have the right to inherit if your parents were married. You don't from either mother or father if they weren't married. And some of the amendments to the Social Security Act that defer to the states were designed to give children of unmarried parents the same rights as children of married parents. And so because of that history that penalized these children unfairly, I'm hesitant to see a system that puts so much weight on the parent's consent, and yet I see the value of doing that. So
Right.
How big a role do you think that should play?
Well, I definitely can see where consent goes to the intent of the deceased individual, which is what we're looking at when we're looking at intestate succession. I have a lot of issues with the standards that courts have used. The time limitation is extremely arbitrary, and I think that in a lot of situations where you have, a wife who's lost her husband and she has a certain period of time to make this huge life-altering decision of whether or not to have a child is extremely unfair and should not affect the child and the child's right to inherit. And the same thing with consent a little bit. I think I said this a little bit earlier, but requiring such a specific intent and such a specific consent in writing prior to death, and a lot of these circumstances are probably circumstances where the husband is not expecting that he's going to pass away, he's going through treatment for cancer or whatever it may be, or even maybe just ignorant to the possibility that this might happen, and are not going to be thinking about, hey, let's get this in writing so that the child can have benefits, So, and then the end result from all of that is that the child ends up being penalized, and I just have issues with that. I'm not sure what the answer is, but I think there needs to be some sort of more flexible approach, or at least an exception to the consent requirement to allow a surviving wife, or in the future a surviving husband or other individual, to prove that the deceased individual intended this result from surrounding circumstances or whatever it may be.
I just have one last quick question, and then we'll open it up to everyone's questions. But the court had said when they granted cert here that there are about 100 of these cases pending before the Social Security Administration currently. So we have those 100 people, and then we have everybody that comes after them. How would you like to see this case come out? What do you think best case scenario would be? Continued deference to the states with the hope that the states revise their statutes in a way that's more compatible with what you want, amendment of the Social Security Act, or remanding it and saying that the Third Circuit was wrong?
Okay. I have never been a huge advocate for change, so I'm going to say that I would stick with that deference to the states and allow the intestacy law to decide. But I do feel very strongly about the urgency that states should feel right now, especially with the commissioner having the authority to interpret that state law. If the case goes to court, that the states should really feel an urgency to specify what they want to happen in this situation.
Questions from your comments?
What other benefits issues, so setting aside intestacy or inheritance under a will, what other benefits issues are there besides Social Security? I guess child support would be one, maybe medical insurance eligibility. Do you know how those have been resolved?
I don't know. Like Professor Seleckia said, a lot of the case law has focused solely on Social Security benefits, so I'm not sure of any cases. I'm sure there probably are some, but I just focused on Social Security benefits, so I'm not entirely sure.
The only other times I could see this coming into play would be if there was a state benefit that was somehow similar to that. If there were pension benefits to surviving children, if it were a circumstance where it was a trust set up by somebody else, or even if it was a recovery, even I could see after an accident or workplace injury where the benefit or the award went to your dependents. By definition, if the person is not born while you're alive, I think there's a good argument to say they were never dependent on you because they were never alive when you were alive. But I could also see in those contexts, if your older siblings depended on the parent for support, why wouldn't you?
Well, that's one of the examples I was thinking about was worker compensation statutes. Mm-hmm. They have
right.
similar definitions of dependent and child, also usually tied to intestacy, but able to prove otherwise, et cetera. I wondered if there have been cases in those areas.
Yeah, not as many. And I don't know if, some of it is people who were planning and just weren't working because they were ill and that was when the event took place. But I think we will see more of this.
Kelsey, what's the reason, why would states be against children in their jurisdiction getting Social Security money?
Under Woodward, one of the reasons that states have been hesitant to do this is because of that orderly administration of the estate. So if you open up that class of individuals that are going to take under the state intestacy law to an endless time period, then those other individuals that are taking from that estate have an extremely uncertain value or expectancy in that estate because children can be subsequently born and have the right to inherit then from the same estate.
So for other rich issues, besides just the fact that this might happen?
I think it just relates to that orderly administration of the estate and trying to provide certainty to the individuals that are taking. Yes.
Thanks. This is really interesting. This reflects how little I've thought about Social Security benefits. Can you just back up? So if Jane and John Doe are married while both are alive, they have 2 children, and then John dies, how do the benefits work in that instance? In the very simple instance.
I think the wife has the right to benefit a certain amount. I'm not sure the exact amount. And then the child, and they define the child as I showed you before in the very first slide. And so the children have the right to, yes.
And it's not needs-based.
Right.
One of the things, so the reason I was asking that question is one of the things that I'm wrestling with is when you had that slide up saying that the Social Security Administration's purposes are construed liberally, right?
Mm-hmm.
So we want to take care of the needs of these children. And it strikes me as somewhat odd to be thinking about someone in a situation who has gone through ART. I mean, I would imagine that in many instances it's not a needs issue, but it's an argument of legal entitlement as opposed to an economic needs. And I'm just wondering if the courts have addressed that issue at all.
I think that's a really good point because I think a lot of advanced reproductive technologies are expensive, so that I haven't seen that anywhere in the cases discussed that the child might not need this, but it's just an entitlement that the child would have a right to.
Yeah, and I think because need would not be considered for the existing children, they have not worked this in.
Mm-hmm.
So it would also be true if the parent was disabled, the benefits are calculated, and so the question would be, do they get the same thing as the existing siblings or not? And so once that issue about what do the living siblings get, once that's resolved, there hasn't been discussion about whether or not these children would be treated differently.
What if the state passed a statute that said, I don't know, it's not part of the intestacy statute, or in the intestacy statute said this is not to be used to interpret Social Security, medical insurance, worker compensation, or any other benefit for a child?
Then I think you could see that division, and I would be much.
Would the IRS recognize that the state was saying that, sorry, the IRS, Social Security, the federal government
was wondering how the IRS was coming into play.
Would that, I'm trying to figure out how the Social Security statute and its regulations would apply in a situation where the state had specifically said, no, you should not use our descent and distribution statutes for this.
I think that's what the Supreme Court is hopefully going to determine when they determine whether or not the Social Security Act can provide for that child, that they may have to change the Social Security Act in accordance with their decision, because right now you just have that deference to the state intestacy law, or you have the dependency requirement, which some courts have said, well, we have a legitimate child, so that satisfies the dependency requirement. Whether or not it does, I'm not entirely convinced, but they might have to change the Social Security Act in accordance so that if they intend to provide for posthumously conceived children.
I think, and I'm reluctant to wade into constitutional waters, but wouldn't there also be a supremacy clause problem with the state telling the federal government, you can't use this for that purpose? Because if I were a probate court judge and I saw all of the arguments that you raised about orderly administration, we want the other kids to know what they have, I would agree with all those, and then if I were a probate judge, what I want the legislature to pass is, I want the kids in this state to get every single benefit that they would get in any other state. So for federal benefits, I want this very generous rule. But in my probate court, I want to wrap these up in 1.5 years so nobody later conceived. And I think that might raise some problems if you have the state telling the federal government, your statute says you can use this, but we don't want you to. But they might be able to get creative. I don't know. Bifurcate it in any way.
I just have that question, and I don't know the answer to it, but certainly there's been tension between the definition of a child for purposes of not wanting to bastardize a child, and so very liberally finding children to be born or to be a part of a family when the issue is family law. And I assume those tensions are still unresolved, but maybe I'm wrong. But assuming they are, then couldn't the statute be redirected to that? Because, I mean, I'm certainly aware of a lot of cases where courts on trial levels will find a child to be born or to be the child of an individual. Maybe they're in a marital relationship, maybe they're not. But the focus is the best interest of the child is supreme. Seems like that has not been taken into account when you would think it would in Social Security cases. Well, I understand the statute sends you the dependency analysis, but could they do something that would focus on the best interest of the children?
I wish that there was a way to provide some sort of bright line rule that would provide for the best interests of the child. I'm not sure that actually exists, but I do think that, as you mentioned, that children born outside of a marriage might come into play here and hasn't really been considered. And then that presumption of paternity in the marriage would obviously work against individuals who were not married and had a child conceived after the death of an individual. So the area that could get extremely complicated, but I definitely think it's possible that it could come into play.
Isn't it true the problem with ARPs is that because of the technology, children could conceivably be conceived, possibly 10, 15, 20, 30, and an infinite number of them, and that's the trouble.
Right.
Is that to limit that so the trouble with illegitimacy or something, that's never going to pose the same analogical problem with these two.
Right.
This could be exponentially. You could have heirs and heirs and heirs. And that's
right.
Do put a limit on time-wise, even recognizing that you might be able to establish the paternity. The time there are time limits. So I mean, you could conceivably do that. I don't know where you put it, but I would think it's
an interesting question. Anybody else have? Yeah.
Well, I was going to say that, I think putting a timeline on it makes some sense. But I'm skeptical that states are going to step in here and start wrestling with these issues a lot because it's such a slippery slope. In these cases that you're talking about, it's sort of easy. Husband has cancer, husband dies, wife has baby, right? But what about we have fertilized eggs, right? Wife dies, husband remarries. New wife can't have baby. New wife gets pregnant with the eggs. With those fertilized eggs. I mean, it's a slippery slope.
Right.
And I think for states to try to step in and more generally address this question with respect to intestacy laws seems unlikely to me, at least in some particular states. But so I don't know. I would think if I was a Supreme Court clerk right now, I would be saying let's try to address this issue with respect to Social Security, since that's where it's arising. And it seems like if the federal government wants to address this, it could.
I think we should write to our congressman.
But
Did you write to your congressman?
but don't you have
We
the
can write to our shadow congressman.
Right, we all can. But don't you have that problem, like, still, because Social Security decides cases, it's not a federal, I mean, the frustrating thing about Social Security is so much of it is individual to the jurisdiction in which it arises. So which is why there's almost this natural affinity to go with the states. So I don't know how you could decide this case without ignoring, by not deciding for the benefit of the whole, but just for the area. I forget what the case is.
So,
Florida? No, I don't think it should. I think it should be, there should be an amendment to the Social Security Act.
It seems to me from the conversation that there needs to be a decoupling with respect to this issue of how it's treated Social Security versus how it's treated from ES. What's your solution?
That's a really good question. If you do separate the two, then it appears that you're creating an inconsistency, at least to me, as far as how the child that was posthumously conceived, what that child might take, and then what the other children will take intestate. But on the other hand, that provides a more simplistic approach to that child's inheritance. So I think, I'm going to stand by my deference towards the state intestacy laws, and I think that the Social Security Act should still defer to the state intestacy laws, but I can see the other side, so it's hard for me to say that, because it would make sense, I think, to separate the Social Security benefits, have that determination be completely separate from intestate succession, and then maybe that posthumously conceived child can inherit Social Security benefits, but they can't take intestate because we need orderly administration of the estate, and we need to determine that within a certain period of time.
Well, Mr. Scott, and then we'll wrap it up.
Coach, you just picking up on Naaman's point, we may have already addressed this. Is it your view that in the absence of the silence of the state on this issue, could Congress, under its power to make conditions for, grant conditions for Social Security, legislate on this issue, quite apart from your views as to what's the best route? Does Congress have authority under the spending power to legislate in this area?
I had con law last year, but I think that they might, but I'm not entirely sure.
Well, see, I'm with Sandy. I think the two of them need to be completely separate, which would then, I think, solve some of the problem, because you would have a change in the allocation of the Social Security benefit. And to me, I think the only thing that's relevant is, do we have a minor child who has a deceased parent? And that, I think, would make it much easier for the purposes of the federal statute. And then all those other concerns, I think, are still alive and well for the states to be concerned with. But I wouldn't see that there would be any problem in redefining how we classify the necessary benefits of the beneficiaries for the purposes of the federal statute. And separate
the federal benefits expert is asking this question. So what do you think, Ted? Is there some reason why Congress couldn't redefine benefits under the social security?
I would think Congress has a broad power to set conditions under federal grant programs.
So you think it would be?
My assumption, I start with the assumption that there's broad authority under South Dakota versus Dole to establish conditions for grant programs generally. And in the absence of state intervention in the area, or state determination in the area, that at least leaves it open for Congress to exercise that power. Whether it will